The Gen AI conversation has been advancing faster than a lot of people can keep up lately, but some new developments have brought older concepts like prompting back into the spotlight thanks to a trending new topic, token cost. Token cost moved into the spotlight recently as tools like Claude gain traction in legal, because most plans come with token limits, as well as the ability to request limit increases, which has resulted in tales of astronomical bills for some users. Recently, Legora also announced that it's moving its Agent Pro offering to consumption-based pricing, which means it's billing by what the agent does rather than by a flat seat license. And what agents do is consume tokens. Eventually, other providers are sure to follow suit. What many don't fully understand is just how quickly token usage can add up. A few extra follow-up questions, a document pasted in twice, a chat continuing long after it should have been reset. If that sounds familiar, token consumption compounds faster than you might expect, and you may be looking at a higher token usage than you think. And you might not even realize it until you've hit your usage limit or worse, seen the bill. This is a blind spot we've been unpacking in one of our latest article series on Legal Tech Hub: how to get more out of tools like Claude without burning time, decreasing accuracy, or racking up unnecessary bills. We cover topics like what tokens actually are and why they function as a hidden meter running behind every chat, when to reset a conversation versus continue in the same chat, and what everyday prompting habits, from repasting whole documents to burying 5 questions in one prompt, might be driving up both cost and inaccuracy without you knowing it. Head over to legaltechnologyhub.com to read the full series and learn more about how to get the most out of your token limits and your usage of tools like Claude.
Welcome to the Geek in Review, the podcast focused on innovative and creative ideas in the legal industry. I'm Marlene Gabauer.
And I'm Greg Lambert. And today we are exploring the modern legal services market through a value-focused operational lens. And we're looking at what happens when you actually apply strategic rigor of private equity to law firms. That's going to be an interesting one. And how those intersect with the ground truth of legal operations on both the law firm and on the client side.
Yeah, we are absolutely thrilled to welcome back a frequent and favorite guest of the show, Brad Blickstein. Brad is the chief executive officer of the Blickstein Group. He's widely recognized in the legal industry as a futurist who's spent nearly 3 decades analyzing how legal services are purchased and delivered.
And just like us, he started when he was 12. So
that's right.
And Brad, we're going to talk about this, but you've been pretty busy lately. This past April, you published a new book, WWPED, which is What Would Private Equity Do? Unlocking Value in the Law Firm You Already Own. And then, as if that wasn't enough, you also released 2 massive benchmark studies, the 2026 Law Firm COO Survey Report in July and the 18th Annual Law Department Operational Survey. So you've been busy.
Yeah, Brad, the underachiever. Welcome back to the Geek in Review.
I have been busy, and I do like to try new things, but I do have to push back a little bit just at the use of the second person singular. There, I do have a great team at Blickstein Group, and they did most of the work that I get the credit for. So I've been busy, but they've been busy too, and it makes a big difference.
Well, that's a good leader that gives credit where credit's due, right?
Absolutely.
Well, I mean, it is my name on the door, so I'm not that. But we do everything.
So, Brad, in your new book, the WWPED, you challenge law firm leaders to stop treating their firms purely as cash flow vehicles for year-end partner distributions and start focusing on enterprise value. You used a great bakery analogy to explain Jae Um's cream, core, and commodity market segmentation. Can you walk us through the difference between an artisan legal bakery and a crumble cookie style system, and why the core segment, representing 70% of the market, is the ultimate battleground for law firms today?
Sure. Let's start with cream core commodity. And the idea is that it's a pyramid. The cream work is at the top. That's just what you think it is. The work where you need a seriously good lawyer to give you seriously good advice or provide seriously good work product. This is where we sort of think about things artisanally, like that work really needs to be done artisanally. Then at the bottom of the pyramid, skipping ahead for a little bit, we have the commodity work, Much of that is already not being done by law firms or is in their captive ALSPs. That work largely has become already systematized or scaled. But there's tons of work in the middle. Jay calls it the core work. Sometimes I prefer the run the company work. The work that, as you point out, Marlene, is we say is 70% of the market. To be honest with you, that's an FMA number. Just a guess, but it's something like that. I mean, it's a big chunk of the market, and this is what law departments spend most of their money on, and frankly, where law firms earn most of their profits is on that. This is where the leverage model plays in for law firms, and much of that work shouldn't be done artisanally, and can be done differently than it is being done today, and can be scaled. And that's really where the bakery analysis is. Like if I don't know, if you're going to the bakery and it is your 25th wedding anniversary and you are throwing a big party and all your friends are going to be there, and you want the best cake you can find, you want something special for your spouse, you want to make it a big deal, you want to go to an artisanal bakery where an actual baker who actually has skills is going to bake your cake for you because that's appropriate for that. On the other hand, like, I don't know, your kid got a couple B pluses in school and you want to bring home some cookies to celebrate. That's very nice too, right? But you don't need to go to that length for that, right? That's something you can go to a more scaled bakery, something like you see these crumbles and what's the other one? The overnight cookie, the sleepy time cookie. There's something else like that. Insomnia cookies, sorry. The opposite of sleepy time, all over the place. And, you can just go there and pick up a bundle. And if you think about how those different types of entities work, like at Crumble Cookies, there's probably not even a baker within 100 miles of the store. I mean, there's a formula, there's a recipe, there's technology that makes sure it goes right. And they put out a very fine product that works for most of the instances where you want to get some cookies or a cake. And I don't think in legal we do a terribly good job always of differentiating between the two. I think there's a lot of work that can be done using technology, using different resources, some scaled sort of way that can actually be more profitable by firms if it's done right. That needs to be differentiated from that artisanal cream work that really shouldn't be. And really what we're arguing for in the book, more than almost anything, is that you should figure out what that work is and scale appropriately if you're a firm.
Yeah. I was afraid, Brad, that you were going to, instead of saying the kids got a couple of B's on the report card, you were going to say your 24th wedding anniversary, you don't go get a fancy cake. And I was going to have to make sure my wife didn't listen to this episode.
Well, I've been married more than 24 years, and I've learned a few things along the way. So you were at no risk of me stepping in that little pile.
Well, I think that's a pretty good argument. I think part of the issue is, firms trying to determine what falls into those. But one of the other issues that we run into a lot, and we're probably seeing it now around the AI infrastructure, is the fact that as a partnership, these firms are really designed to distribute the profits at the end of the year, not having anything roll over. So when you see things like Kirkland announcing that they're going to put $500 million into AI infrastructure over the next few years. One, not every firm can do that. And two, I laugh because I still remember talking with a partner who said his wife remembers the 1 month that he didn't take a draw because they were putting some funds into the future. And he said that was like 10 years ago and she still remembers that. So, it's just outside the norm. How do you convince firms that just aren't used to doing this to actually figure out a way to build for the future?
Yeah, that's a great question. And so not everything is for everyone, right? Like not every strategy that you can deploy here is for every firm, but it is one of the advantages of taking some outside investment, right? And that's where you can smooth that over. That's where you can use the PE funds, the funds from PE or whomever for either some original payout to your partners or to smooth that over time, or use that money for the outside investment. That's one way to do it. The other way, and again, I just sort of alluded to, is sort of pick your spots. I mean, that $500 million is a lot of money for everybody, but over 3 years, which is, I believe, what it is, it's not actually that much money can't believe I use those two things in the same sentence, but not that much money for Kirkland Partners, which, they have enough partners to spread that out very nicely, right? So it's not, and, one thing I wonder that the partner that you talked about, like, did they say to his wife 3 years in advance that 1 month straw might not be coming? There's
No,
expectations
I
that need
can
to be
I can
set.
guarantee you he told her the month that it happened.
Right. So there's some of that too. But one of the big arguments that the book makes is that you don't need to take outside investment to do some of the things that a PE fund would say this is what a firm should be doing. And I listed out there's 10 different things in there, but you don't have to do them all at once, right? So one of the things that I really believe in is that law firms should professionalize pricing. And if I was a PE fund investing in law firms, most of the time, almost the first thing I would suggest to them is bring on a serious professional pricing operation to fix that. And I'm not even talking about
What does
alternative fee arrangements or flat.
professionalizing pricing mean?
That
There's
exactly,
firms have
professionalized.
pricing groups, so what are you saying that's different?
Well, some firms have pricing groups. Some large firms
Fair.
have pricing groups.
Fair.
Most firms do not have pricing groups. Certainly, most mid-sized firms do not have pricing groups. In a lot of cases, those pricing groups have been neutered or not really listened to. And in most firms, it's still often like a partner's gut as to whether or not they could pass through, whether or not they have to discount or can pass through a price increase. In a lot of cases, like the engagement partner feeling like they can't get that across. They can't sell that to their clients right now without necessarily the right data to back it up. So again, not everything is for every firm, but I think there's a lot of firms, and it's easy to imagine, like, I don't know, a couple, 3, 5 points across the board if you bring in the right types of pricing function, the right type of pricing function at your firm, and that's goes right to the bottom line. Pick your spots. Like, don't do everything that we're suggesting here at once. Where can some of this PE thinking really impact value? And start there with a bite that your partners can digest.
Let's look at the findings from the July 2026 law firm COO survey. A historic shift occurred this year. For the first time, technology investment and adoption surpassed talent acquisition as the top strategic initiative for law firms. Yet 38.1% of the COOs identified practice silos as the number one structural issue that they would fix, and 27% cite a lack of operational authority. Why is there such a persistent authority gap for professional managers tasked with executing these high-stakes technology strategies?
Yeah, I think there's two answers there. One is just in the relative power of the folks who are expected to do that work. I mean, at a mid-sized firm, the COO was probably might have had some title like administrator, literally the same person, title like administrator a couple of years ago. To what extent do the partners really empower that person to run a firm like a serious business person would be allowed to do? I mean, you hear a lot of this from the COO type folks that, like, this is what I'd like to do, but the partners won't let me. So I think there's that. I guess there's three issues. One is there's also a pretty big delta between their opinion of leadership and their opinion of partners. So leadership is often more supportive of business initiatives from COOs than the partners at the firm are. So there's that disconnect too. The leaders managing partners totally behind me, but then when I try to roll it out, through the partnership, I mean, I'm sure you guys live this and breathe this.
Never seen
right?
that. Never.
Right. Exactly. And I do think that it's sort of some evolved thinking for me, some new thinking for me, but I mean, big firms especially, I do think that practice silos are sort of an underrated problem. I mean, it's not only different partners think differently, but different practice areas are built differently or designed to do different things. We understand why they're thrown together in a firm, but in a lot of ways, they're really not necessarily alike enough that some of these systemic changes can be achieved totally firm-wide, practice by practice, when in a lot of ways the IP practice and the M&A practice are run super differently and are built very differently.
When Marlene was giving you that question, I was thinking, one of the worst things you can have in a position of authority is all the responsibility and none of the authority to actually do what you're assigned to do. And I wonder, one of the things that you pointed out was in the survey was that there's a rise in COOs that are coming in from outside of legal to take over the COO roles, which I think makes sense. A lot of us want to run things more like a business, right? So we look at business folks to bring them in, but then we throw them into the legacy law firm environments. So how do you keep from bringing someone in and giving them all the responsibility and none of the authority?
That's
another book.
Such yeah, maybe that might be an encyclopedia. That's I think a lot of that actually comes down to where is power consolidated within the firm. I mean, if you're talking about a small or mid-sized firm where leadership really has consolidated a lot of the power, I think it's a lot easier. I think when that job becomes a consensus building job, I think that is very difficult. And frankly, if you came from outside of legal, I think that might really be an impediment. I mean, if you come from corporate America where, it's hierarchical and what the boss says goes and people generally stay in line, I think working at a law firm where that's inherently not the case is definitely problematic. One thing that's really instructive is, and I'm oversimplifying, of course, but, plaintiffs firms don't have this problem. I mean, very often. I mean, there's usually one or two people's name on the door. There's a big boss who really is the big boss of those firms, whether or not it's literally their name on the door, whether or not it's, Tiger Law or something, like that. And they tend to be, rowing in the same direction with fewer kind of practice areas. And they've been able to bring in a lot of talent and a lot of innovative business strategies that folks on the corporate and defense side really struggle to bring in. So it can be done. It just takes a consolidation of power more than or either you got to be a world-class consensus builder or there's got to be some consolidation of power above you with the firm, I think.
Yeah. I was going to ask you, what advice would you give a COO that's coming in from outside of legal?
A little bit, I think, a little bit of patience, a little bit of Zen, make sure you re-up your blood pressure medication before you start, but, it takes the right kind of
roll
person.
in some yoga and some meditation,
breathing exercises,
and fight the battles you can win. Don't.
Yeah.
But if you pick the battle, you have to win the battle. Like you can't lose the ones that you've decided to fight. And I think that's a good lesson for COOs too, which is that, think carefully about how badly you really think something needs to happen, how important it really is, because if you're going to use up a lot of political capital and possibly burn your reputation when you lose that battle, maybe it's one, think about how bad you need to fight it.
Yeah, makes sense. So one of the most, I think striking statistics in the COO survey is 66% of the COOs report their firms do not formally measure or document AI-related efficiency gains. And 39% of those same COOs expect AI to increase revenue via greater lawyer productivity. So if firms are saving time, but they're not measuring it, are they actively devaluing their own services? How can a firm defend pricing under a billable hour model? And of course, we may talk about maybe doing something other than the billable hour model when AI is actively compressing those timelines and the firm has no baseline data to price the alternative fee arrangements.
It's a conundrum. It's a problem. I think that first of all, I think that number of folks who are formally measuring or documenting, that number is going to go up, right? There's no way we're going to continue to not document anything. And let's be honest, while it can be hard to analyze and use, like the data is there. These are people who measure everything they do in 6-minute increments, right? Like it's not like there's, this actually, we can talk about this later, but that's actually going to be a much bigger problem in-house where they don't track what people do on a daily basis. But at law firms, they do. So it can be suddenly that number is going to change. I'm really fascinated by this AFA question because, I've been tracking this so long. You guys know I was one of the founders of Corporate Legal Times magazine. And in the 4th issue that we published, this was in 1992, we published an article and the headline was Alternative Billing Making a Comeback. Right. So 35 years ago now, it was already making a comeback. So this idea that
any day now,
so we're almost here. And I think the idea that like clients are going to make firms do this I think that's largely been disproven. I mean, it's true around the edges, and there's 15% or whatever that do that. But I think the idea that like firms are going to go with AFAs because their clients are going to make them go with AFAs, I think that as a hypothesis has been disproven over the last 30 plus years. However, now we're getting to a point where it may be the firms that need to do this, right? Not only for client satisfaction because they think their clients want to, but it's going to be the only way to make money. So I'm not as concerned about the 66% that in my mind are not yet tracking. I'm much more concerned about the 39% who say that they're going to increase revenues through greater lawyer productivity. Like what model is that going to happen? I mean, better productivity, should decrease revenue. I mean, maybe it allows you to bring on more clients and thereby, make enough of it back that way. But I mean, I think that's a pretty nuanced thing that I'm not sure the market is quite seeing yet. They're starting to get their arms around it, but I don't think anyone's solved that. I think I think firms are going to have to measure productivity better. I think they're going to have to understand this better, and they're going to have to go to their clients and say, look, like these projects that used to take 10 hours, we can't bill you 1 hour for. Or I guess we could if we just bill you, $7,000 for that hour, but we can't. Doesn't really work. How can we bill you in a way that you can get value and we can take advantage of the efficiency gains, at least to some extent for ourselves. And that to me, that's the battleground. Like that's what we're looking at.
Right. I'm gonna switch up my question just a little bit now after hearing your answer there. I heard this earlier at a conference earlier this year. Was why would clients now want to do AFAs when they think it only takes 1 hour instead of 10 hours to do it? So where's the motivation? But really, I think my question is more on the how do we get past the trust factor that, let's move so that this is beneficial for both of us, because we tried this in, 2008, 2012. And, it was like, hey, we're going to do alternative fees. And the clients are like, yeah, I don't trust you. I still want you to tell me, I want to do the alternative fee, but I also want to tell you to tell me how many hours did this take so that you're not, that you're not getting one over on me, to put it politely. How do we get past that?
That's a great question. And that is such an underrated issue. I mean, people love to blame firms for the fact that, that AFAs largely haven't implemented, but the fact that law departments the clients don't trust their own firms. I think that's a big issue. I mean, that shadow billing issue that you just mentioned is huge. I mean, if you're a firm, you're effectively just putting a cap on the amount that you can bill without putting a floor on the amount that you can bill. It doesn't work for firms. I think that's going to be a place where we're going to have to have a bit of a crossroads. So the first thing you got to remember is that, clients like sending work to their law firms. I mean, they like working with their firms. They would prefer, despite all the talk about bringing work in-house, and I know that's a giant trend, like, all things being equal, most general counsel would just prefer to continue to send work to their firms. Now, all things are not equal, and they're less equal than they used to be, right? So it's not necessarily fair. But I mean, I think that I think that firms are going to have to be a little more transparent without having to go all the way to like this number of hours we're spending. I think firms have to do a better job of, and this is so hard, but enunciating the value of the work they're doing in any other way but the number of hours it takes. And I think, and frankly, I think firms need to stand up a little bit more. I mean, it's very rare. That shadow billing question is a good one. I mean, if you're a firm and you get asked that by your client, the proper answer is no. Like, we will not share the number of hours this work takes with you. That's, either you feel like you're getting a fair amount of value for the work we're doing, or you don't. And if you don't, we got a problem. We'll talk about that. But, our hours that you put in is not really your business. You have to say it a lot nicer than I just did. But I don't think that goes on enough out there. I don't think that firms push back enough on their clients when they get asked that, to say, look, if the whole point of an AFA is valuing the work and not the time, and by the way, the amount of time it takes to do the work is not the same value as what the work is worth. We have to figure out a way to work together to provide good work for good value, and not good work for a certain amount of time. I I'm just
It's
preaching
a
at this point, though. I don't really know how to do that.
it's a really good point, but it's so interesting because you're getting that type of detail in terms of the questions, when there's sort of pitches or if there's RFPs, like they want to know exactly, clients want to know exactly how much time it takes to do things and how much time you're saving. And it's a difficult thing to respond to, the way you're saying, when they are specifically asking for this type of information.
It's very hard to pivot that conversation. I think when you ask that question, I think the way to pivot the conversation is just, let's not talk about how much time we're saving. Let's talk about how much money we're saving. Like, here's what we used to bill you for this type of work, and here's what we will bill you now for this kind of work. And you can ask how long it's going to take, but really, what does it matter? But really easy for me to sit here on your podcast to say, go tell your clients we're not going to answer your questions. I mean, it's hard to do, and it takes some fortitude. But I think if you can establish that value, and if you've built up trust over time with your clients, and I think the other thing that you can maybe do is start to think about, especially if we're talking about AI, what the other value propositions around AI might be. Can you actually get the work done faster? I don't mean in less time. I mean done faster. Can that deal close faster? Can that litigation be settled faster? In a due diligence, can you review more things than you used to be able to? I mean, in a classic due diligence used to be send us your contracts with your 25 biggest clients or something like that. And because that was all the due diligence team would have time to look at it. And now, like, you can use AI to look at all the contracts, right? So what's the value proposition around using that AI that isn't just tied to efficiency? So you tie that with an actual cost savings and not a time savings or a number of hour savings. And you stand up and you say, look, we respect you, but we've thought a lot about this. We spent a lot of energy on this, and we think you're asking the wrong question. Let us answer the right one. I think, a lot of clients are going to say, well, they didn't fill out our RFP properly. Too bad. But I think a lot of them are going to respect that and want to work with a firm that is thoughtful like that.
So I'm going to shift to the buyer side. So the 18th annual Law Department Operations, the LDO survey, shows a corporate legal buyer that is stabilizing structurally but absorbing broader business mandates. And that's including CFOs stepping directly into contracting. And meanwhile, corporate Gen AI adoption is defined by piloting, and that's 52%, rather than fully operationalized systems, which is 23%. So why are corporate legal departments stuck in this pilot purgatory, and how does the middle mile data hygiene problem play into this?
Yeah, I think that's part of it. First of all, considering that we're really 2 or 3 years, depending on how you count, really into the AI era, I'm not sure it is purgatory. I mean, I think we're in a lot of ways, we're sort of working our way through this. And I think I expect that number to go down substantially over time. I think part of that is also caused by just, there's just so much noise out there. I mean, how can you possibly figure out if a tool is worthwhile for you these days without kind of giving it a shot? I think it's really hard. So I don't know, I think we're going to get there. But I think this data hygiene problem is going to be an increasing one. I think that whatever the old saying is, garbage in, garbage out, all that stuff, and I think we'll solve the data protection problem. I think people understand and are starting to already, like, how to be more comfortable, how to not freak out over who's maybe how they're using my data. I mean, the idea of, like, we want our law firm to provide every possible ounce of efficiency they possibly can by using AI tools, but we're certainly not going to allow them to use our data for training data to help them do that. Like, it's not really fair. Like, that doesn't make, I think we'll get past a lot of those type issues over time. But, I mean, data in corporations is a mess, and it's going to have to be sort of, to get full benefit out of tools, you're going to have to solve that in a lot of cases. And I wonder how many pilots are going to fail because of that, where, the tech is good, the adoption is good, the training is good, and the data's not there.
Yeah. It's a big, big issue.
It's a big issue
in terms of making, getting this data usable and where you need it to go, and making your tech useful.
My hope is,
I mean, it's not a new problem, but
I was going to say, this is a 25-year-old overnight problem.
It's not a new problem, but it's I don't know if it's easier or harder. I mean, the technology is so much better, but then the security issues are so much more difficult. So I'm not really sure.
Yeah, I think that's what I'm hoping, I guess, is that, if you look at e-discovery over years, like, technology created the e-discovery problem, right? Like the ability to disperse data so fast and email everybody and copy a million people. Like, so the data problem was created by technology and then ultimately largely solved by technology with things like auto review and platforms and things like that. So, I'm hoping that maybe AI can help to solve the data hygiene problem in and of itself, thereby enabling AI to work better to actually solve the legal problems that that data can solve.
I know in the survey, this was the first time, and of course, AI has only been around 3 years, I'm sure, for the last 3 or 4 surveys. But this was the first time that usability got a higher score that beat out security as the top AI priority for legal operations teams. I think what this opens up the door for are unique opportunities that have never been available for law firms to offer services to their clients. Are you seeing clients having that expectation of being offered something that they've never been offered before? Are they receptive to things like that?
I think they're absolutely receptive to that. And if I ran a law firm, I would be trying to get ahead of all of this. I'd be trying to build things and find new use cases and do things that I could bring to my clients before either someone else does or before the client tries to build something like that themselves, right? So anything and all the work the client's trying to bring, that you're concerned the client might try to bring in house. But if I ran a law firm, I would be okay. Let's think about what that work is that they might bring in house, and let's go build a case for them why they don't need to bring it in house, why it's a bad idea, like why we can do it more efficiently and better at a better price here at the firm than you at the law department going through all the trouble to bring the work in house. I don't think we're seeing firms bring that to clients enough. I think that when firms do bring it to clients, I think they're extremely receptive to that. And I think that ALSPs are starting to get involved in that. But if I was firms and ALSPs, I would be building offerings and bringing them to my clients before the client decided to go find a solution.
Yeah. Well, speaking of ALSPs, Well, why have ALSPs not just wiped the floor with big law? It seems like everyone expected, because they have these repeatable processes that they're supposed to do. Why are they not just kicking ass?
Well, first of all, I think some of them are kicking ass, right? I
Okay.
think that when you start to look at them as like a percentage of the overall market share of the legal market, it seems somewhat stagnant. But when but a lot of these firms are doing themselves, they're on big growth curves within the ALSP. I think that I really think that there's a lot of reasons, but I think the big one is that clients like to work with law firms, and
That's what they
that's
know.
their preference. And if it's not working, or if it's the kind of process or kind of project that makes sense to take away from a firm, doc review is a great example, right? Like, law firms largely proved the case that they should not be in that business by throwing a million associates and no technology at doc review 20 years ago. And legal service providers and e-discovery providers have thrived there. If it's a case where it's, a type of work that's really obviously process oriented, I think that ALSPs are doing quite well. But I think that a lot of what they have to do comes back to that artisanal argument that we made before. They have to convince their clients that there's a bunch of legal work that isn't artisanal in nature and can benefit from process and technology, and that ALSPs are the people who can deliver that.
Okay, so Brad, what's true today that wasn't true a year ago?
Yeah, I think it's that legal organizations, both in-house and outside, are starting to care about what AI costs. Legora, I'm almost sure it was Legora, talked about how they're moving to a
Yep.
consumption model. I think that is a big issue for folks. I think they're starting to worry about, they're moving from this, let's get everyone to adopt whatever they can and use AI wherever they can, into hold on a second, like, is this, what's it really going to cost when we start paying by the token? Does it make sense? The entire underlying assumption is that using AI to do this work is less expensive than using lawyers. There's at some point, if AI gets expensive enough, where that may not be true even anymore. So I think that was not true a year ago. Everyone it was the gold rush was on, and now I think people are starting to wonder, like, what stream should we be mining? Or well, I think I just picked a metaphor, but where should we be drilling, or where should we be looking, or panning? Where should we be panning for gold? I think is what I'm asking now. Are these price increases going to stick? Are open models going to be more valuable and more possible? And I think those are good questions. So this might be. I believe that this is something people are concerned about today that they weren't concerned about a year ago. I'm not sure yet how long it's going to stick.
Yeah. Mm-hmm. Yeah, it's going to be interesting to see, because 6 months ago it was, burn every token you can get your hand on, and now it's like, whoa, wait
a minute, hold on there.
I'll also say that I think and it's related, we're starting to see some folks make the distinction between adoption and like fluency, right? Like,
yep.
It felt like the standard was activation and then maybe adoption. Like 98% of our people have used the tool in the past month, which is a nice stat, but really doesn't speak to whether or not people have become, AI proficient or AI fluency, and if they're using it for the right things, or using
in terms of what they're doing.
Yeah, and I think as we start to ask those questions, it's going to impact, where the value really is and what these tools are really worth as well.
Yeah. Well, Brad, before we started recording, we looked back at your last prediction on the crystal ball question, and I think you did pretty well.
Yeah, he did.
So your prediction at the end of last year was that generative AI and LLMs would fundamentally accelerate how software and tools are built in the legal tech space, and that you thought there'd be like an 80% improvement in how much speed it would get in turnaround from idea to actual product.
That does seem to be happening, and I think I would say that especially if you count the things that are being built within firms and law departments themselves using whatever, vibe coding or using Claude coding or all those things, I think that I think we can check that off as one I got right.
All right. Now it's time to ask you again. What kind of change or challenge do you see that law firms, law departments need to be prepared for over the next few years?
Yeah, so I'll answer two different ways. Double my shot at getting something right. Generally speaking, I think this issue of the business and billing model is at some point going to have to come to a head. I mean, maybe in the next 2 years, not quite as much, but at some point, law departments are, and exactly how they're going to do this, I have some thoughts, I don't know, but are going to put pressure on firms to reduce the number of hours they bill in one way or another. And if you're a firm, that doesn't work for you. Like that's not under the leverage models. At some point, we're really going to have to start to come to terms that a lot of firms with that issue. I also think that when you start looking at all these, I'm not a big fan of the AI native term, but if you think about these AI native type spinoffs from firms, I mean, can partners leave a big law firm and start a firm with no associates, and the idea of using AI instead of them and go to those same clients but trust them with that new model? I think, external forces like that might actually end up pushing firms more than their clients do to make some of these changes.
Well, that is food for thought. So, Brad Blickstein, thank you so much for joining us again and helping us cut through all the noise and think like value-focused operators.
Yeah,
and thanks to all of you. Sorry, go ahead.
Thanks, Brad.
Thanks, guys. Really appreciated this. It's always so fun talking to you and thought-provoking, and you ask such questions that make me think hard about what the responses should be, which I don't really appreciate, but I do really like.
We do,
really
though.
Like talking.
We appreciate it. We appreciate it.
Yep, he had a full set of hair before we started this.
It always reminds me of that scene in the movie Clueless where they think she has a concussion and they said, ask her some questions, and they go, what's 7 times 7? And they go, stuff she knows. Like I would prefer if you ask me, stuff I know.
And thanks to all of you, our listeners, for taking the time to listen to the Geek in Review. If you enjoyed the show, please share it with a colleague. We'd love to hear from you on LinkedIn and Substack.
And Brad, what's the best place for listeners to go out and find and buy the What Would Private Equity Do?
Oh, easy.
Learn more about the Blickstein Group.
Yeah, you can go to our website, blicksteingroup.com, or for the book itself, blicksteingroup.com/WWPED. Or, and I've always wanted to say this, it's available wherever fine books are sold online. So you can get it from Amazon, you get it from bn.com, wherever. No, it's not that hard to find. And, we appreciate the support.
Absolutely. And as always, the music you hear is from Jerry David DeSica. Thank you very much, Jerry, and goodbye, everybody.